Tel link, you have a prepaid call from
Free. Try it again.
an inmate at the Salinas Valley State Prison, Soledad, California. This call and your telephone number will be monitored and recorded. To accept this call, say or dial 5 now.
Hello.
Thank you for using Global Tel Link.
Hello, Rudy.
Hello, we got cut off. I'm not sure what happened.
Yeah, I'm not sure. I tried to call just before that call, and it said that there wasn't any money on the account. I don't know. Was that a mishap also?
There should be money on the account, so I'm not sure what's going on there.
Well, there has to be. If you didn't put any on in the last 3 minutes, then there has to be, because it wouldn't go through otherwise.
Right.
And I apologize for calling so much that I want to get through this 3552 all the way, and I hope that's all right.
You bet. You bet.
If it ever becomes too much, just tell me, and I'll back off. So
no problem. And there's a letter on the way to you, by the way. And your friend Barry Armitage is trying to write up some one-page summaries where people can read about your case, and other people have been contributing. So that letter's on the way, and you got a lot of people out here that love and support you. But the floor is all yours.
Well, thank you so much for that. Let's go into the 3552 because we're on the last item. There actually is number 36. We went through item number 35, which was, let's see, my whole testimony was tainted by coercion, disallowing me to really put on any kind of defense that I wanted to put on, and that was by my own attorney, as were most of the problems in this case. So there's a 36 item, which is separated from the rest because it's not really an evidence tampering type of a thing, but it's like the coup de grace, it's like the capstone of all the rest of everything, and that'll become obvious when I explain what they did. It's about jury instructions. There were 24 jury instructions that were necessary to determine self-defense acquittal based on the evidence. Had I been allowed to put all the evidence in that I wanted to, these 24 that were not given, that were important to give, and had I not had an attorney standing in my way and been doing my own trial myself, even without an attorney, I'd have made sure that all these jury instructions were given. Let me see what I've got here exactly. I'm not going to go through all of them, but let me go through some of them that are very important. The jury, of course, didn't know about what instructions they weren't given. They were not given, I was charged with murder, first-degree murder, which I was acquitted of by the jury. There's a lesser included offense of second-degree murder, which is what I was convicted of. Then there are lesser offenses in that, which are manslaughter, voluntary manslaughter, and then there's a lesser offense in that, which is involuntary manslaughter. Those two, manslaughter and involuntary manslaughter, with a half-time credit on the sentencing that you can get for good time, working in the prison, amounted to about 4 years and about 2 years in prison, as opposed to the 35 years I've done so far. Well, and then there's the self-defense instruction, which was a standard instruction about self-defense. All of those were not given to the jury. What they did is, in secret proceedings behind my back, while I was in the courtroom waiting and not knowing they were doing this, they held secret proceedings after the rest of the trial was over with and the jury was about to deliberate. In those proceedings, they withdrew the manslaughter instruction, so the jury could not. Actually, they withdrew the involuntary manslaughter instruction, so the jury then had no option to convict me of involuntary manslaughter. Then they sort of withdrew the voluntary manslaughter, because what they did with it is every place in the instruction, and it was probably about 6 or 7 different times that instruction was referred to in the instruction packet, there's a phrase in there that says, that I acted under sudden quarrel or heat of passion. Well, sudden quarrel was obvious. He attacked me kicking down my door by surprise. They took a black magic marker and blacked out sudden quarrel and heat of passion in every place where it stated that, so that it gutted the instructions, so that it was as good as useless. Every single place, the judge did that, and it was by the stipulation of my attorney with the DA running the show. The DA.
This call and your telephone number will be monitored and recorded.
He wanted this and that done, and my attorney just went along with everything he wanted. Then he took the self-defense instruction, a standard instruction, which could have got me acquitted completely, and the DA, with my attorney's stipulation, pulled that instruction out and put in a different self-defense instruction that pretty much nobody had ever heard of. It was never used on a regular basis by anybody. And later, a few years after my trial, the California system, whoever decides the jury instructions of that thing, probably the bar and the judges and courts and whatnot, I think a court actually ruled that that instruction was flawed so badly that it had to be discontinued and could no longer be used. And yet I couldn't get the benefit of it because that was, long after my appeal went through the system. So they acknowledged that self-defense instruction was flawed and useless, to where what it said basically was, it said the jury had to believe that I intentionally killed in order for them to choose that instruction. So if the jury believed I didn't intentionally kill, and being there was bullets left in my gun, fully operative gun, and that he was still walking around on his feet when the police got there at my call to save him, that's obvious that I didn't intend to kill him. If I had intended to kill him, I'd have just shot more bullets at him. But so the jury was not allowed to choose that instruction based on the instruction's wording. So they really were forced to choose between first-degree murder and second-degree murder and had nothing else to choose. They acquitted me of first and convicted me of second. So that was a scam that my attorney ran behind my back. I was on bail the whole time until the jury pronounced me guilty. I was on bail for 8 months before the trial and all through the trial. And during that time, I was on my own, coming and driving to the courtroom and back home and such at each day of the trial. And when they have private proceedings like this in California, they're allowed, even though they're unconstitutional, shouldn't be, but they are allowed by tradition, where the reason they don't bring a person into these proceedings is because the person's in jail and it costs a lot of money to bring them out of jail into the courthouse just for that purpose, to sit in those proceedings. But those proceedings, as I just described, are probably the most important proceedings of the whole trial because the jury instructions were decided there. So there was no excuse to not have me in that meeting. I was sitting right there in the courtroom. My attorney lied to me. He told me I'm going into a proceeding that has nothing to do with your case. I have other clients with this DA, and we're dealing only with other people's cases. It wasn't until I got the transcript long after I was convicted that I found out it was a secret proceeding where they went through these jury instructions. So that was a major, major scam. Another major scam I want to bring up, it's not in 3552. That ends the 3552 right there. Another scam that I want to bring up related to the jury is they delayed my trial for 8 months, violating the right to a speedy trial, which is a constitutional right. My attorney was in on that as well, helped the DA do that. The DA's reason for that was so they could fabricate a case against me, so they could little by little manipulate the memories of the witnesses, their witnesses, so that they would, originally they stated things that were sort of in my favor, and little by coercing them or by restating what they stated, and I heard all this on the police tapes that were later destroyed, the police would restate what they stated with little incremental changes in them, and they'd say, oh, I didn't say exactly that. And then in the next meeting, a week or two later, they would just leave it go, where the police would restate and rephrase and bend what they said. And little by little, they did that 5 or 10 times with these various witnesses, to where the witnesses eventually testified to the eventual thing that they got to, which was totally different than what they originally said. And I believe that some of those witnesses did that unintentionally. It's just a way to play with a person's memory. And there's actually a lot of psychology information on this in psychology books about how they tweak a person's memory like that. So that was one of the reasons that they delayed 8 months, to have the time to do those little incremental changes with witnesses against me. But the main reason was they said it right before Labor Day vacations, and they stacked the jury by statistics. I don't have any other evidence of this, but just by statistics, it would have been possible to get 2 panels of potential jurors of over 100 people. Not one of them believed enough in firearms to own a firearm. So I believe that they pre-screened all the jurors, and they made sure that all the selected jurors, except maybe one, had Labor Day vacations. And some of these vacations had been paid for a year to a year and a half ahead of time. There are people flying to Ireland and going all over the world to various continents and various other places where they were rendezvousing with their relatives for these family reunions that had been planned a year and a half in advance. There's no way they were going to avoid any of that for a trial. So when they were selected, they talked about all that, and they were given assurance that the trial would end by a certain date, by September 1st, so they could get to their Labor Day vacation. Some had to leave right on that day, and that was the day I was convicted. So what the DA did is he ran a scam where he used most of the trial time and left a short time, a little bit of time for us, maybe one tenth or 1/20th of what we needed to put on a good defense, but we had to close it up by August 31st. And so we did. So I didn't get to put on hardly any of what I wanted for defense at all, even if I'd had an attorney that, was in my corner and not working against me secretly. And then it went to the jury without me being able or allowed to put on a proper defense whatsoever because of that scam. And they acquitted me of first-degree murder on August 31st. Then they went home and got their sleep for the night, came back on September 1st, the day that some of them had to leave for their vacations, and all of them had to leave within a couple days of that. And they found me guilty with a rushed verdict in the morning, just a couple hours, because they had to get onto their vacations. That's what was on their minds, not whether or not they were sending an innocent man to prison. So those are a couple more of the scams that they ran. I wrote down some other ones here I wanted to get into that are sort of related. Let me see. I mentioned to you, but I don't know if we mentioned it in this session. I don't think we did that. I've never had a public trial because my attorney pulled another scam on me where he told me that none of my family, none of my people none of my supporters, local community, none of them, we had a packed courthouse. There were 100 and some people wanted to come. Not one of them were allowed to come because he said any of them he might choose for character witnesses, and you can't be sitting in the courtroom that he calls a witness. And I later found out that he never intended to call them. He admitted that actually later after I was pronounced guilty. And I also found out that when you're character witnesses, you can sit in the courtroom and go testify because your testimony has nothing to do with any of the actual evidence, like the crime scene, for example. So I didn't have a public trial. I don't know of another case in U.S. history that can say that. I've never been able to find one in the in thousands of cases, tens of thousands of cases I've researched. I was convicted on a standard of proof that's used for civil trials, a preponderance of evidence. They gave the jury the instructions saying that the standard of proof was beyond a reasonable doubt and not preponderance of evidence. But my attorney got up in front of them and used his body pictorially as he was also stating this. So it's in the transcripts where he used his body as a big balance beam scale, his arms off to each side as the balance beams of a scale, and he kept saying whichever side weighs more heavily, that's the side, guilty or not guilty, that you choose. And that's exactly preponderance of evidence standard. And he reinforced it in their head over and over and over with his body as the picture of the scale, and they allowed this to take place. It's just unbelievable. That is a preponderance of evidence standard, and that's what I was convicted on. So I'll turn.
Well, let me just interject for you. Preponderance of the evidence, and it's whatever tips the scale. But if you're going to send somebody to prison for 35 years, as in your case, doesn't it have to be beyond a reasonable shadow of a doubt or something like that?
If you're going to send somebody to prison for 2 months, or if you're going to send somebody not to prison but just to fine them $5,000, if it's a criminal case, you have an absolute right that they can't even, it's not even debatable. It's not even supposed to come into the picture to do anything but reasonable doubt standard. And I'm saying they claim they did a reasonable doubt standard because they say, well, we instructed the jury on this and the instructions are clear as to what it is. But that was overridden by the fact that this clown attorney of mine stood up in front of them and for an hour and a half or 2 hours kept reverting back to, remember again, ladies and gentlemen, the balance beam scale, whichever one weighs more, or this side not guilty or this side guilty, over and over and over, reinforcing that. So that image was strongly in their head that would have overrode any jury instructions.
You have 60 seconds remaining.
Okay.
No way they could have gotten through there was 54 jury instructions they were given in the time that they used to convict.
Got it. Got it. Quick question. I was talking to Pat Shannon today, and what is the short answer to, if you were sentenced to 17 years in prison, why have you been in there 35 years? And I kept telling him, well, you've been denied your parole time and time again because the guards keep writing you up just before your parole on some sort of, raising your voice to the librarian and things like that. But is there another answer? I mean, what's the short answer to how come you spent
30 seconds remaining.
35 years?
Well, yeah, there is. First of all, supposedly raising my voice to the librarian, because I never did that. That was a straight-out lie. And I never do anything that they accuse me of that's wrong, even if it's minor stuff like that. They're just straight-out lies. I make sure I toe the line more than anybody I've ever seen and do not do anything.
This call and your telephone number will be monitored and recorded.
Yes, there is an answer to that. I will try to call you back if that's all right.
Yes, please, please.
If I can't get back with you today, I'll call you back another time.
Okay, my question is, when he calls back, he got sentenced to a certain amount of years, and those years were not 35 years such as he spent. So even if you get denied parole based on fake, faulty, fraudulent write-ups from the guards about raising your voice to a librarian, which he did not even do. He doesn't even, he maintains his innocence on that. The question is, how in the world have they kept him in there 35 years? I mean, it's kind of... I don't quite understand it, but if he calls back, hopefully we'll get an answer to that question.
This is Global Tel-Link. You have a prepaid call from...
Free. Trying again.
An inmate at the Salinas Valley State Prison, Soledad, California. This call and your telephone number will be monitored and recorded. To accept this call, say or dial 5 now. Thank you for using Global Tel-Link.
Rudy, let me address two things real quick I have on my notes here to you before we jump into that issue we just talked about. One is the last defense was supposed to run one more segment of that last series, and they didn't even run it the other night. So I don't know what happened in your area, but in my area they didn't even run it. They had something else on. So I don't know if it's going to run this week on Tuesday, which is tomorrow, but if it does, it's going to be the last one. If it doesn't, I guess it's all over for the whole season. The other thing I wanted to ask you is, I suppose everybody has heard of Coast to Coast Radio with George Norrie. Used to be with Art Bell. Are you familiar with that?
Absolutely, yes.
Okay, can you contact George Norrie? He has 3 or 4 phone numbers he always gives out on the air. I don't have any of them written down right here, but can you try to contact him and see if he could possibly do what you're doing, which is to get me on his show? Couldn't do it live probably because he's on at like 1 o'clock, starting 1 o'clock in the morning here, I think, or maybe midnight. But maybe he could do a recording like you're doing, get me on the air. That would be great because they've got millions of listeners probably all over the world on that station.
What has
try to do that?
Yeah, I can certainly try to do that. What has worked in the past, I've got another man who spent 15 years in prison. He just made an appeal, and I recorded his appeal from prison, and he just spoke as if he was speaking to, and it was John B. Wells in that case. And then I sent the message to John B. Wells, and John B. Wells actually allowed him to come on the show, and that actually worked out. But with George Norrie, I can certainly send the message, and I'll be one of hundreds of people that try to get through, or maybe thousands of people that try to get through. Or if you want to, just ask right now, I'll record it and I'll send him the little snippet of where you're trying to talk to him, and that might get Okay.
I'm not really prepared right now.
Okay.
So my thinking is in this other direction. So, but if you can do that, and anybody else like that other person you just mentioned, that was the other thing on my list here. Along with that, is any other stations that might be interested in this kind of thing that I might be able to...
This call and your telephone number will be monitored and recorded.
By all means, you started the ball rolling with your show here, so I'd love to see if we could open the doors now to a bunch of other ones as well.
Well, and just as I do often try to contact these bigger shows, and it's such a wonderful thing when a breakthrough does happen, but so often they ignore me. But it doesn't stop me from asking anyway, so I will ask. But going back to that other question, and I'll quickly set it up again. I was talking to Pat Shannon. Okay. You obviously got some sort of sentence at sentencing for second-degree murder, which you maintain your innocence on. It was a self-defense shooting, but they gave you a certain amount of years. I would be interested to know what that certain amount of years are, and how in the world have they maintained you in prison for 35 years?
Here's what it is, and it's another scam. The sentence that I was convicted, the sentence I was sentenced under, the law that I was convicted under, was not written up by the legislature of California. We are one of many states in the union, I think more than half the states, that have initiative and referendum where any person that's a citizen of the state can draw up a bill and put it in and get the requisite amount of signatures prior to the voting time and get the people of the state to vote it into a statute. So it becomes a statute just as if the legislature passed it. So that's what happened in this case, and it's so badly written, and it's so long and drawn out, and it encompasses so many things in violation of the state constitution, by the way, which has a single subject clause, which says you can only, you can only put one subject into your bill, and they put numerous ones in. It was promoted as the death penalty bill. They wanted to bring back the death penalty after a real liberal Rose Byrd, Chief Justice in California, eliminated the death penalty. So they did bring it back by this law, and so it was supposed to be limited to that because a lot of jurors wanted to vote in the death penalty, but they didn't want to increase second-degree murder, which is indistinguishable from manslaughter in many cases. They didn't want to raise that up to a possible life without possibility of parole, which is what they're trying to do to me. So it violated those clauses, but anyway, that's how it was voted in. So I'm starting with that foundation. It's very poorly written. So there's been debates for all these years since that went into effect, I believe in about 1980 or 81, right? Within a year or two before my case came out, maybe 82, that there's been all kind of debates as to what even it's saying the sentence is. But there's one key. It keeps saying for first-degree murder, 25 years to life, and it keeps saying for second-degree murder, 15 years to life. But what does that mean, 15 years to life or 25 years to life? That's the question. So what they keep saying now it means, and I had a semi-secretive memo that was in private chambers of the DA and a few judges and some other people that got together right after this bill was passed, and that memo, they decided, here's what we want it to mean, so here's what it's going to mean. And they were all state agents, of course, and they took off in a different direction for what it obviously meant. The key to the whole thing, and I didn't discover this till years after I was in prison, because we all stopped reading before it gets into the death penalty aspect of that bill, which is way, way back in the end of that bill. But it's in Penal Code section, I believe, 194. I can bring my penal code to the phone next time and tighten this up, but I believe it's section 194.4a. It states that if a person is convicted of first-degree murder by a jury, and they have special circumstances alleged, which is, for example, killing more than one person, killing a police officer, torturing somebody, whatever. Anything that's special circumstances. There's a list of about 25 special circumstances in there. If you're charged with any of those, the jury then has to decide those. They have to unanimously decide yes or no. If they can't decide every one of them, yes or no, then they have to be dismissed. The conviction still stands, but they bring in a second jury panel just to decide those special circumstances. If that second jury panel cannot decide every single one of them, either all unanimously yes or all unanimously no, then the judge has a choice. And here's the critical part of that statute. The judge has a choice to either A, bring in a third jury panel. It's the last time he can do it. If they can't decide unanimously for at that point, then they're not. The special circumstance will not stand. Or he has the choice to himself pronounce the sentence of, get this, I'm quoting it, state prison for a term of 25 years, period, unquote, not 25 years to life. So there's the whole key to the whole statute. If you are not if you have no special circumstances, and I had none ever charged, let alone convicted of, if you had no special circumstances, you could only be convicted and sentenced to 25 years to life for a first-degree murder, and that correlates to the 15 years rather for second-degree murder. So only by special circumstances can it be raised up to a life top sentence. So it can go from, let's say in my case, second-degree murder and special circumstances, which are also listed in that statute, it could go from 15 years to 20 years to 25 years, 30 years, or a life sentence, depending on how many and how bad the special circumstances were. But if no special circumstances were found guilty unanimously by a jury, and as I said, none were even charged in my case, they cannot, it's a 15-year flat sentence. So I was supposed to go home, not in 15 years, and I had 2 years for the firearm enhancement, not for 17 years, but for half of that, because we also, according to our sentence, it is written right into the law, and it was written right into my sentencing hearing, that I also could get half-time credits, which means for every day in prison, I got 2 days credit, which means my sentence was cut in half of 17 years, 8.5-year sentence, and that's how I got the May 1st, 1992 parole release date. And that was supposed to be a solid, unmovable parole release date unless I lost some of those good time credits by bad behavior in prison. And, of course, they wrote me a lot of false rule violation reports to take away some of those time credits I earned, but I got them all back because you can get them restored by doing certain things. And I got them all back. So my sentence was fully served at 8.5 years. The scam is that the parole board claims, and the CDC and the judges have gone along with it, and the DA probably spearheaded it, or excuse me, the Attorney General of the state spearheaded it, is that they claim that 17 years to life means an entity of a sentence called 17 years to life. And this is what they've been doing. And that means they can keep you in prison for life, that you had possibly, your first opportunity was that you could have gone home in half of 17 years. That's how they're running the scam. But it's clear in the penal code sections, as I just stated, one section, there's another section that says even if you're interpreting this as 17 years to life as a sentence entity that I'm under with a potential life top for whatever reasons, it's clear in another section of Penal Code 3041B, it states that they can only keep me in prison past my minimum eligible release date of May 1, 1992 if two things. One, I have a crime history that's so heinous that I'm still a danger to the community after I've fully served my sentence. And, of course, I have no crime history whatsoever, so not even jaywalking tickets. So that they don't meet the criteria in invoking the exception to keep me any longer than May 1, 1992 on that basis. The other basis is if the commitment crime that I'm in here for is so especially heinous, like let's say somebody, killed a whole family of 8 people and tortured them first and lit them on fire and chopped their heads off and did that. And their behavior...
This call and your telephone number will be monitored and recorded.
It's still so violent. At the time they got to their minimum eligible parole date, which means the sentence was fully served, then they could keep them longer because they're dangerous to the community. So they're invoking that on me. I've never hurt a person in my life except for the self-defense shooting. I've never wanted to hurt a person. I've never had a violent streak in me. I've never done anything violent or even destructive. Not one destructive thing to anybody ever except this self-defense shooting in my life, in prison or out, from the time I was born to today.
Wow.
And yet they're invoking those things on me, saying that I'm such a danger to society that they can keep me for the rest of my natural life in increments, pretending that they're going to release me by taking me to the parole board and each time denying me again and again and again in the installment plan, making it a life without possibility parole sentence. Here's what's interesting, too. They're about to do away with life without possibility parole in California. There's so much reform in the sentencing and in all the different stuff going on in California. They just passed all kind of bills in the last year, in the last 2 years, in the last 3 years, that they're giving, they're stripping away all the juvenile life without parole. They're letting the juveniles, go home, knock their life tops off, go home like 20 years before they were going to, if they had a parolable sentence, or if they had a non-parolable sentence with life without, they're letting them go home. All these reforms are being done. And so they're going to do away with life without parole soon in California for everybody, even the people who have it already. But because I don't have life without parole, I have a sentence that says I'm to go home at this time, I won't even fall in that category. It won't be written, the bills that they've been putting in that haven't passed yet are not written in such a way that would allow me to get the benefit of that because I'm not under life without parole. Yet somebody else who was convicted of something 1,000 times worse or 10 times worse, who got life without parole because it was so much worse, they'll be able to go home because they're under life, quote unquote, life without possibility of parole, and that'll be done away with. But I won't because I'm not under that, and they'll keep playing this game until we stop it.
Free, as you're talking, no, I'm here, Free, and as you're talking, it's just overwhelming the amount of injustice that you have suffered. I got to ask this question because I'm a very simplistic individual, and I'm thinking just and you covered all the details, and I followed you, but I got to ask this question. And
there's one more.
Okay, all right, okay.
No, but you go ahead.
Okay,
You go ahead.
Okay, so you know, you had the terrible defense attorney. You got a false verdict. It was a self-defense shooting. They came back verdict guilty on second-degree murder. There's obviously a sentencing phase of the trial where you had to go for sentencing. The judge in the sentencing transcript, if I was to have that, there's going to be at least one paragraph when I scan down the sentencing transcript that says, you know, free Lazor, you've been found guilty of second-degree murder. You hereby will go to prison for blah, blah, blah. It's going to have a number of days, right? Number of years or number of months. And what phrase?
Here's what it says. Right?
Okay.
Here's the answer, and I already gave it, but here it is again. It's called 17 years to life.
Gotcha.
But look what you can do with that phrase, 17 years to life. You can either say that means what the statute says it means, that only with special circumstances.
Gotcha. Okay.
Would it escalate up to life? So it should have been stated as 17 years. But instead, by using the whole phrase 17 years to life, making that entity a sentence in itself, instead of saying 17 years, or instead of saying 30 years because of these special circumstances, or 40 years because of other special circumstances, or life because of special circumstances.
Okay.
They manipulated it to say that the phrase is a sentence entity in itself. That's why we have the problem.
You have 60 seconds remaining.
I follow.
Here's another part of the sentencing scheme in the penal code that says that a person has to be found suitable for parole. This is the biggest scam of all that they're running right now. I won't have time to finish it in the next few seconds we've got. I hate to stretch your dollar so far, but if I could call back.
Sure, you bet. You bet.
I don't think anybody's waiting for the.
Yeah, call back. We'd love to hear
again, and we'll jump right.
Okay.
We'll jump right into this.
You have 30 seconds remaining.
Oh, wait, still got 30 seconds. So, anything else on your mind?
No, that's it. We'll finish up when you call back, and it's absolutely phenomenal how they've stretched this 17 years to life to 35 years when you have no criminal history, no special circumstances. Yep. You didn't torture anybody. It was self-defense. Yep. It just absolutely mind-boggling. Our prayers are with you, and I pray God works a miracle soon. We'll look forward to you calling back, Free.
Thank you. I'm all for that miracle. Okay. I'll call you right back.
All right.
This is Global Tel Link. You have a prepaid call from
Free?
An inmate at the Salinas Valley State Prison, Soledad, California. This call and your telephone number will be monitored and recorded. To accept this call, say or dial 5 now. Thank you for using Global Tel Link.
Yeah, we had a momentary delay there, but I was fortunate to even get back on at all. So, what is it we were going to jump right into? Remind me, because I'm going through 3 or 4 other subjects here in front of me.
No, I think you cleared up exactly what the phrase that was used at sentencing. You went through all the details of how the scam they're using to keep you in prison, you know, at 35 years and counting. We said we're praying for God has a miracle, and you said you had one additional thing that came to your mind you wanted to cover.
The one additional thing is this. There's a section, and the reason I know these penal code numbers are not important to the average person out there listening unless they want to verify, but I'm hoping that somewhere through all of this there'll be an attorney out there who will just be so astounded at the corruption in this that they want to get involved. And so for that type of person, these are important. So I'm just going to throw them out there anyway. Penal Code Section 3041C, which is part of the sentencing. 3041 is part of what I'm under, but 3041C is not part of what I'm under. If you go to the old penal code that was in effect when I was sentenced, that's what we have to use, because what they've done in changing those things today does not apply to me. But what's interesting is the legislature in California has violated the law terribly, because they've made changes in that, and they just assume that I'm dumb enough to not know that those new changes don't apply to me. So now in section C, subsection C, there's a phrase that says if the parole board feels that a person is unsuitable for parole, this is an important word, quote that word, unsuitable, then they can, under those circumstances I mentioned, they can keep in certain people until they find them suitable for parole. Or it actually doesn't say that. It doesn't go that far. It infers that maybe one time, the first time they come up for parole, they can find them unsuitable. But it then says this clause applies only to Section 1170.2 of the Penal Code, and then you go back there, and you find that it says very clearly, this applies only to people who were in prison prior to the sea change of law that took place in 1978 or 79, which was SB 42, Senate Bill 42, which took all the sentences in California except for one or two crimes. All of them were 2 life sentences. And that's where they got this 2 life business the way they applied it now, because every sentence in California, even if you had 2 months of sentencing, it's actually 2 months to life, which meant that you were under a life sentence, but you could get out as early as 2 months or 2 years or 6 years or 8 years or whatever. But every single one of them had a 2 life top on it. And so guys were being held in prison for 8-10 years on a 2-month sentence, where guys that had a 6-year sentence were going home before them in 6 years, or cut in half in 3 years. So they stopped all that. The governor jumped into it from the executive branch. The judicial system jumped into it from the California Supreme Court, and the legislature jumped into it from the California legislature's position. They all got into it and said, this is all wrong, we're going to change it. So they changed it. So that was a major sea change, where they took off all the life sentences and started letting slews of people go home, a whole great exodus out of the prison system in California. So how that applies to what I'm talking about is that under that code section that the suitability clause applies to is only for people who were pre-SB 42, in other words, who were in prison under that 2 life sentence. It does not apply to anybody else. So the suitability clause has no applicability to me, because I came in prison several years after that sea change. And yet they pretend that clause doesn't exist, and they just say that the California Supreme Court ruled about 15 years ago in a case called Henry Dannenberg. It's a landmark case. John Dannenberg, who was a friend of mine in prison, by the way, they stated, which was harmful to everybody, that you don't have to be released under the clause I mentioned earlier. In other words, when your parole release date comes up, you don't have to be released if the parole board says you're unsuitable for parole when you've got this so-called 2-life top, 15 years 2 life instead of just 15 years flat. So what they've done is they pretended that suitability applies to everybody else, and it does not apply to me at all. And now you can find it in 8 or 10 other places in the penal code. So the legislature has jumped in and made changes to this law that was put through by the people on an initiative of referendum, and you can't do that. You can't take an initiative law that was passed by the people and later have the legislature come in and make changes to it, because then you're changing what the people voted in. You follow me?
Yeah.
So that's very important, and yet they've done that, and everybody's blind to it except me. Everybody's not paying attention to it, not reading it. And that's exactly what it says, though. It's very clear.
This call and your telephone number will be monitored and recorded.
I have put these things in the court, and they procedurally bar me. They don't, all these issues, all the evidence tampering, everything, have never been addressed by any court. They always procedurally bar me, saying, oh, you had your one chance at bringing these things like 30 years ago or 33 years ago, and you didn't do it. Well, of course I didn't do it. I didn't know about them. It took years to dig this stuff out, decades to dig some of the evidence up that they tampered with. So I don't know if all that's clear that I said about the subsection C suitability clause, but that's the whole big thing now. That's every time I go to the parole board, they say, no, we're finding you unsuitable as a danger to the community still, so we can do this for the rest of your natural life. Every however many years we want to go before we bring you back to the parole board, 3 years, 5 years, 15 years now, they can put me off if they want. However many years we put you off, when you come back, we'll just keep doing this again. And that's a life without possibility of parole, perpetual sentence, till I die in prison, if we let them get away with it.
Yeah.
And yet that's completely corrupt. That's not the way the law was intended. That's not even the way the law is written anywhere. That's not a proper interpretation of the law. It's a no-brainer. These things are no-brainers that I'm saying to you. Just somebody besides me has to get them into court, somebody that's got some clout, and that they'll pay attention to and not procedurally bar them. Somebody can get through the procedure bars. It's corrupt beyond anything imaginable.
Yeah. You know, it's just, you have an amazing story, and I pray that God allows your words to hit the right ears to make the miracle happen, that you get out of there.
Well, thank you. I sure hope that of course, I hope that I work every day for that. Let me mention another thing I've got here in my notes. This is just where I made some notes earlier in the day today about these various things like the balance beam scale, preponderance of evidence and such. Here's a whole different one. The jury did not convict me of the firearm enhancement that put the extra 2 years on that 15-year sentence. They had the jury instruction on the first-degree murder that they acquitted me of. they wrote in there, they checked the box true that I used a firearm, but then they changed their minds and they acquitted me of first-degree murder. So that whole thing, that whole verdict form, got thrown out as far as any applicability, including the original check in the box where it said true, or maybe the word was written true in the box, because the whole thing was then nullified when they said I wasn't guilty of any of that. So then the second-degree murder form, that's the one I got convicted on. It has a little box that says, if you feel that the person used a firearm in violation of the law to commit this offense, then write true in this box. That's what it was. It wasn't checking a box. It was writing the word true. So it didn't have the word true in it. And so the judge said in open court, he turned to his clerk named Corrine Rose. He said, Corrine, take that verdict form and write true into it. And she wrote true, and he said, initial your initials next to it. She wrote CR for Corrine Rose, and it's there on the verdict form today. And that's what I got convicted of, was that firearm as well. Now, this is significant for a number of different reasons. One is that should void the entire, even though the jury did find me guilty of second-degree murder, it should void the entire thing because that's a forged jury verdict form. But more importantly, the judge, when I had a lot of people come in to speak at my sentencing hearing after the trial, then my attorney couldn't keep these people out of the courtroom. So a bunch of people came and spoke on my behalf. And when they kept speaking, asking not to sentence me to prison, to give me probation or whatever, because they knew darn well I didn't do anything wrong, the judge kept responding to them, the law says that I have no choice in what I sentence him to. I can only sentence him to 17 years to life in prison. But if the jury hadn't found the special circumstance, well, it's not a special circumstance, if the jury hadn't found the extra charge of the gun enhancement true, then he didn't have to sentence me to prison. So he could have exercised an option. I mean, probably wouldn't have, but from a legal standpoint, he could have exercised the option to not send me to prison at all. He wasn't bound by sending me to prison for the conviction of the murder alone. He was only bound to send me to that supposed 17 years to life by the fact that there was the firearm enhancement found true. So, being that the jury didn't find me guilty of that, he could have sentenced me to something else. I didn't discover this till I was in prison several years. And so it's very important,
This call and your telephone number will be monitored and recorded.
A falsified document. Now, to my knowledge, up until just a few years ago, I thought that was all in the transcripts. He carefully kept that off the transcripts, had the transcriber stop, so that wasn't transcribed. But Corrine Rose, Gail has talked to her, the girl that actually wrote the true in and wrote her initials next to it. She would admit today, if she's still alive now, Gail talked to her last about 2 or 3 years ago, that is exactly what happened. And everybody else in the courtroom at the time that saw that, whatever jurors are still alive and whatever people who were there in support of the conviction and not in support of me, they would also be able to testify to that fact, because it was shocking that the judge actually made that ruling. So another big piece of fraud that is a first. I've never heard of anything like this out of the tens of thousands, maybe over 100,000 cases I've researched in the last 35 years, because I used to do this 16 hours a day and not hardly sleep, and just do this day after day after day after day, except just taking off the Sabbath most of the time. I did this for 25, 30 years straight, nonstop.
Wow.
And so I've researched maybe over 100,000 cases, and I've never found a case with any of the kind of fraud like I've been reciting to you over the last few days.
Yeah, it's absolutely incredible. I'm going to get all this out and pray to God that God uses your words, again, to reach out to somebody who can make a difference. And, I make a statement often, Free. I say, for people that are going through this brand new, you've been at it 35 years. I can't even begin to imagine me saying that phrase, 35 years. What a shocking phrase. But for people that are just now getting pulled into this satanic system and they're spending like their first few months and they haven't even had trial yet, my advice to them is don't underestimate how wicked the system can be to you. And then I also try to, tell them that I do not appeal to the corrupt system to fix itself. My appeal is to heaven, because I believe the system has gotten so corrupt that they're not going to fix themselves. It's going to take an outside force, like almost a miracle from God, to fix some of the problems that you're experiencing and others throughout this country in our satanic judicial system.
Yeah, I agree, except I might take out the word almost.
Yeah, right.
It's going to take a miracle.
It's going to take a miracle. Yeah, exactly.
Yeah.
Exactly.
So, yeah. So anyway, there you have a lot of things, and let me say this: out of all the many things we've talked about in the last few days, especially all the 3552 and these various other things, this is a tiny, tiny bit of the tip of the iceberg of the fraud and corruption in my case. I mean, these things. The 3552 to me is one little entity here. There's another little entity here, another little entity here, and these little entities might be a lot bigger than the 3552, and they're very different. And there are dozens and dozens of them in my case, which is why it's been mind-boggling and overwhelming for me to try to deal with this case, especially on my own without attorneys. Here's another thing that happened. The state-appointed attorneys on appeal I could have had, but when they gave the address, and I realized the address was just right next to my attorney's address, realizing how bad he just sent me down the river, I immediately got myself out from under that, thinking, well, okay, they're going to have all this corruption in that too, and I'm not going to get a fair appeal. So we went and hired the very famous Twinkie defense attorney, Dan White, Douglas Schmidt, who got Dan White off on that obvious first-degree double murder in San Francisco, the very famous case of Twinkie defense. Well, it turns out Doug Schmidt was an excellent trial lawyer. He's very flamboyant when he wants to be in front of the jury, and is excellent as a showman, and that's how he got that guy off that shouldn't have got off. But we didn't know the difference. He didn't know diddly squat about appeals. He was not a seasoned or experienced appeal lawyer. On this one? Yeah. Okay, so this guy's got a phone call sign up right now, so I'm going to have to go. But anyway, we hired him and had a very bad appeal, and he wouldn't put anything off record, so I had to do it myself. All the habeas corpus stuff, which means the stuff that's not on the appeal record.
You have 60 seconds remaining.
I didn't know what I was doing, of course. I was brand new at all this. And so had I had the public or the state-appointed attorney, they had excellent attorneys, and they had a lot of money to put into investigators and whatnot. So, all right, I got to go.
Okay,
so
there's a letter. There's a letter in the mail to you. Should arrive today or tomorrow or the next day about Wesley Schroeder, because I did find him on the internet. And God bless you, Free. Our prayers are with you.
All right, thank you.
Okay,
thank you. You take care.
Okay,
all right, bye.
Bye-bye.